Welcome back to Court TV Live, along with Julia Jade. I'm Ted Rollins. Good to be with you. We are going back to Miami, Florida. We've seen the state's initial close. Now it's time for the defense in the toxic relationship murder trial for Daisy Link.
And Link's attorney is representing a 30-year-old woman from Homestead. She's accused of shooting and killing her on-again, off-again partner, who she was married to, Pedro Jimenez, back in June of 2022. So let's listen in and hear what the defense uses in their closing argument in front of this jury.
Stay with you throughout this trial until you go back there and deliberate. When you're back there deliberating, if you decide that the state has proven their case beyond all reasonable doubt, then that's another story. But she doesn't lose that presumption until you reach that decision, if you reach that decision. If you remember, because it's been weeks already, but during jury selection, there was a juror sitting in the back, in the corner, and we were talking about that example that I gave about the cat and the mouse and the hole in the box. You all remember that? Okay. There was this one juror who was sitting in the back, and he said, I can't make a decision because I don't have enough information. Well, as I explained to him, the cat is presumed innocent. You're not convinced that the cat's guilty, right? No, I haven't been convinced. Okay, well then, your decision is not guilty. He's presumed innocent, so your verdict, right? Your verdict is not guilty. If that changes, if you're convinced otherwise, then you change it. But if you're not, the verdict is not guilty. It's pretty simple. I would submit to you that right now, before I say another word, every single one of you should vote not guilty. I'll explain in a moment, but you should, because the state has not overcome the reasonable doubt in this case. Now remember, I will remind you, I don't have to prove that Ms. Link was justified in pulling the trigger. They have to prove that she was not justified, and they haven't. Now, I want to talk a little bit about some of the things that the state said a moment ago. They said a lot. They said that Daisy was upset because Pedro wasn't home. There's no evidence of that. They just made that up. There is no evidence of that whatsoever. Whatsoever. Point to one witness, one piece of evidence that establishes that. You won't find it because it hasn't been introduced. It's their burden to prove it. They want to say something, they want to allege something, they have to prove it. They can't just get up here, say it, and say, oh, you got to believe us because we're the state. Believe everything we say, believe nothing that the defense say. We're the good guys. It doesn't work that way. They have to prove it. Daisy's mother flew in for a barbecue? That's what he said. You know that's not true. And they didn't even have that barbecue. And yes, they were going to have a barbecue the next day. You heard why. Number one, because she lives in Texas and she has other family that she doesn't get to see, so she's going to see them. And number two, they don't want to make it obvious that Daisy's leaving because they don't want Pedro to flip, which he did anyways. But they don't want him to flip, so they're doing it in a way that he won't find out. That was the testimony. Have they rebuffed that testimony? Have they proven that it's not true? No, they haven't. The most that they've done is, well, maybe it's true, maybe it wasn't. Have they disproven it? They have not. Can you point to a single piece of evidence, to testimony, to anything that rebuffs that? You cannot, because it doesn't exist. The state mentioned about phone calls between Pedro and Daisy. Pedro didn't have a phone because he tossed it after he almost beat Daisy to death a few days before. And then he had to get another phone, and you heard testimony about that. You heard testimony about that. When he went to his friend Kevin's house to do all that coke and to buy all that cocaine so he could have a party while he's driving a big rig across the state, snorting cocaine, he didn't have a phone. He didn't have a phone because he tossed the phone after he almost killed Daisy a few days before because he didn't want the police to track him.
Objection, back on evidence.
Overruled.
It wasn't evidence. She testified to it. I'm not making it up. I'm telling you what was in evidence. You can use your own recollection about what you heard But we all know that that came out in evidence. I'm not making it up. The state has repeatedly said that was their home. No, it wasn't. They can't just say it and say, there, we proved it. They haven't proved it. This thing is really blurry. But for future reference, this is Defense Exhibit A. It is 3 pages long. Pedro Jimenez had 2 driver's licenses. These driver licenses, both of them, can't see it here, but you can see it yourself when you go through the evidence. Both of them have his mother's address. You have seen lease agreements where he is not on the lease document. You have heard testimony from multiple people, including his son, that said he didn't live there. But most important, this is Exhibit F, Defense Exhibit F. This thing's horrible. You can look at it when you're deliberating. This is a court order. A court order. Now, the judge read the instructions, and I'm going to tell you exactly what the instruction that she read to you says. And I am talking about page 11 of the instructions, which you will all have with you in the back. Parental rights. The court has taken judicial notice that there are no court records in Miami-Dade terminating the parental rights of Pedro Jimenez. That is right. During my opening statement, I told you he lost his parental rights. I didn't say terminated, I said lost. When your parental rights are terminated, that means it's terminated. That means there's no coming back. They're gone. When you lose your parental rights, you can get it back. And this order provides a pathway for Pedro Jimenez to get his rights back.
The defense here wanting this jury to stay laser focused on not only Pedro Jimenez, the shooting victim here, but also asking whether or not the state has proven that he wasn't violent in that moment, despite everything else that Daisy has done. I think that is going to be a challenge for the state.
Absolutely, and also that layered, Daisy on the stand with the the reason I lied, the reason I didn't call police is because I didn't want him to be deported. I didn't want him to lose his ability to see the kids, and I didn't want to lose the kids.
Yeah.
So
there's a lot
we'll
of
see.
for sure.
Passion on both sides. Let's get a break. More of the defense closes in the case against Daisy Link when we return.
Tonight on Closing Arguments, a parent's worst nightmare. A 5-year-old girl left unrecognizable after she was brutally beaten by other children. We'll dive deeper into this tragic case.
Closing Arguments, tonight at 8/7 Central, only on Court TV.
Donna Edelson wasn't a regular mother.
She's the matriarch mastermind.
She's just being a parent, not a killer.
Victim to Verdict with Ted Rollins. Season finale, Saturday night at 8 Eastern and Pacific.
Only on Court TV.
Let's get you back inside of that Miami courtroom where a woman is on trial for the murder of her on-again, off-again partner. Daisy Link told police that she shot Pedro Jimenez in self-defense, claiming to have been the victim of years of abuse. But prosecutors say that she's lying and that she fired at Jimenez in a fit of rage while he was running away.
Let's go back in the courtroom, pick up more of the defense close.
Pathway is first page, bottom. Substance abuse assessment, individual therapy, parenting therapy, domestic violence. domestic violence. September 20th, 2019. Ever since September 20th, 2019, that man was limited to seeing his children by court order 1 time a month under the supervision of his mother, who you've heard doesn't even live in this state. And you've heard no evidence or any indication that she ever came back, because she didn't. And he gets to have FaceTime calls with the children at the sole discretion of the mother. The sole discretion of the mother. Do you think courts and judges limit a parent's ability to see their children flippantly and for no reason? They did it because Pedro Jimenez was a drug addict, a cocaine abuser, an alcohol abuser, and a wife-girlfriend abuser. And, as you've heard throughout the course of this trial, he was doing nothing to get those rights back. He was doing the opposite. He was on his way to losing them permanently. Why? Because 5 days before he died, he beat Daisy Link halfway to death. Beat her halfway to death. Smashed her skull in. Did it in front of his 7-year-old son. Did it in front of his 5-year-old daughter. Did it in front of 4 other kids. 4 other kids who were present. The state got up here and told you Pedro was not dangerous? Are you kidding me? Is that not the very definition of a dangerous man? He proved what he's capable of just 5 days before this happened. The state said a lot of things during their closing. I didn't agree with any of it except for 2 things. One thing that they acknowledged, Pedro was not a good guy. I agree. No, he wasn't a good guy. No, he was a cokehead, wife-beating lunatic. That's what he was. He terrorized and traumatized Daisy Link. He terrorized and traumatized his own children, and he terrorized and traumatized other children. This is a man that was capable of beating a woman halfway to death in front of children, in front of his own children. That's dangerous. Whether Daisy acted afraid of it or not doesn't change what he did. Whether Daisy made a flippant remark or made fun of him or insulted him doesn't change what he did. The state wants you to ignore and forget that he did that. Well, they can ask you to forget whatever, but you know what happened. This order Paragraph 3 of this order, Exhibit F, the minor children, Pedro Jimenez and Mia Jimenez, shall remain in the legal and physical custody of the mother, whose name is Daisy Link. Next paragraph, the non-custodial parent of Pedro Jimenez and Mia Jimenez is Pedro Jimenez. And then further down, Pedro Jimenez has not substantially complied with his case plan. A brief description of this plan is as follows: substance abuse treatment, assessment, individual therapy, parenting, domestic violence. He didn't do it then. He wasn't going to do it in 2022. Quite frankly, it's clear that he was never going to do it. He was less concerned with getting back his kids and having more time with his kids, he was more concerned with getting high and beating up Daisy Link. The state will tell you that Pedro was broken, that Daisy did all these horrible things to you. They completely ignore what he did to her. And you can't ignore that because that goes to her state of mind. That goes to her state of mind right when she pulled the trigger. Yes, she went to pick him up, and I'll submit to you, that was a bad choice on her part. But you know what? Relationships are complicated. When two people love each other, even if it changes, it's complicated. When you add children to the mix, it's complicated. When you add property to the mix, it gets more complicated. When you add the fact that these kids, even though they're bad...
A little bit of ownership there from the defense attorney saying, yes, she made some bad choices, but the state can't discount her being a victim here. Let's bring back in trial attorney Alexis Rosenberg, see what she thinks about the defense and how they're going so far. It's going to be a lengthy closing argument. They got a lot of ground to cover, Alexis. But how do you think they are doing in terms of making this defendant more the victim than the person who's the villain in this story?
I think he's doing the best that he can, given the facts that he's been given. But here's the problem. Even if they had this toxic, violent relationship, remember, they have to, the prosecution has to prove that at that moment, you know, that, and the defense has to say at that moment it wasn't self-defense. So, and they also have a big hurdle because I don't think she's very likable based on her behavior and comments that have come in either.
Yeah, it's a good point. But is he likable? And do you think that the jury is just going to throw their arms up and convict her because they don't like any of these players?
I don't think that the deceased is likable. I don't think the jury is liking the deceased. I think that it is believable that their relationship was violent, that allegation. But once again, was it self-defense at the moment that this happened? Not all the stuff leading up to this, but at that moment.
How much of what happened before, Alexis, plays into this? It sounds like the prosecution is trying to downplay what happened 5 days before. There's this allegation of a pistol whipping where she says Pedro pistol whipped her, but there's a text that Pedro sent to her saying, how are you going to pistol whip me right after you know, you did it first and then I did it to you only afterwards. So it sounds like there's a lot of mutual combat here. How much of that for a juror will play into what happened in this moment? Because this didn't happen in a vacuum.
So I think for the jury, they are going to hear that. They're going to see that this woman, based, if you take what the defense is saying, was a severely traumatized, beaten, and battered woman on a regular basis and daily, if not every moment, she was in fear. And I think that if they can get the jury to believe that, but we have this other evidence coming in that she was the aggressor sometime as well.
Yeah, and the state did a great job of, you know, sort of getting across. She was angry. She wasn't scared. She was angry, and those are two different things. It takes two to tango, that thing. It's going to be fascinating to see what this jury does. Alexis, as always, thank you. Let's get a break.
Yeah, more of the defense closing coming up after we come back. The toxic relationship murder trial for Daisy Link.
This is a toxic relationship, and she just lit the fuse. I cheated on you, you're right. You're never home. And so she says, my husband of 9 years, I just shot, let me go find him. So you can't take back a murder. Her rendering aid, attempting to render aid, lying to officers. Lying to officers is relevant. Rendering aid is irrelevant. You can't take back a murder. And she goes this way and up and back. We know she doesn't go this way, there's a car blocking it. We know it's not this way because her car ends up over here. And it's important. She goes this way, up, and she walks over to Pedro's body, turns her car off, and takes his items out of his pocket. His phone, his money, his keys. She goes back and then starts rendering aid. It took her time. These are deliberate steps that she took.
That's the Miami prosecutor delivering his closing argument. Welcome back to Court TV Live. I'm Julia Janae. Thank you for following along with us with this trial out of Miami, Florida, where the toxic relationship murder trial is underway for Daisy Link. And the big question is going to be for this jury, was this self-defense or murder or manslaughter? Attorneys are delivering their final arguments to the jurors right now. Link is charged with second-degree murder for shooting and killing Pedro Jimenez back in June of 2022. But she says the only reason she did it is because he became unhinged and dangerous outside of her home where the kids that they shared were, and she believed that he was going to hurt her. But prosecutors say no, she was the aggressor in the relationship and she tried to cover it up when it was all over. Let's get you back into the courtroom now. The defense giving their closing argument to the jury. Let's watch.
When you have the fact that these kids, even though their dad's not a good guy, they love their dad. She knows that. So yes, she doesn't want to get him arrested. She doesn't want to get him deported. She doesn't want to do that. She just doesn't want to be with him anymore, and that's her right. And why would she want to be with him? He beats her up. He did so for almost the entire course of their relationship. And you need look no further than this order to know that. The state went on to say that Daisy Link picked up the casing, the spent casing in this case. There's no evidence of that, ladies and gentlemen. None whatsoever. They can say it till they're blue in the face. They have to prove it. It's their burden. And if they haven't proved it, which they haven't, then you can't accept it because it hasn't been proven. There's no evidence that she picked up any casing whatsoever. She was with police for almost an entire day, from the point they got there at 3-something in the morning, till she got to the station several hours later, till she started her 11-hour-long interrogation at what, 9? So she was done, what, the following evening? That's almost 24 hours. They had eyes on her the whole time. But they want you to believe that she found this casing and she got rid of it. Well, that doesn't jive with the evidence. There's no evidence of it. She told them where the gun was. She called 911. She tried to help this man as soon as she found him. And the only reason she didn't call 911 sooner is because Pedro stole her phone. The state said that the officers were kind to her. Are you kidding me? No, they weren't. They say that she threw a chair at Detective Morales. Well, she didn't. There's no evidence of that. None whatsoever. There's 100 officers on there. All of them have body cams. Have you seen a single body cam of her throwing a chair at anybody? No, because she didn't. The state talked about Pedro Jr. They said one thing, and this is the other thing that I would agree with, that Pedro Jr. is a very smart boy. I agree, he is a very smart boy. Kids are honest. Yes, they are honest. I would submit to you, Pedro Jr. was honest in his testimony. I specifically asked him, and he specifically said, I'm not telling you, nobody told me what to say. This is what I remember. Has he spoken to his grandmother in the last 3 years? Yes, because he lives with her. What's he supposed to do? What's he supposed to do? Because he speaks to his grandmother, therefore you shouldn't believe a word he says? You can judge that boy's credibility on your own. We have footage in this case which was deleted. It was lost while it was in police custody. The police only viewed one snippet, which is when Daisy Link went to Pedro while he was lying there. They didn't bother to look at anything else. They didn't bother to look at any other footage when he stole her purse or when he was running back and forth 3, 4, 5 times that he was running back and forth that Daisy's mother told him to leave, that Daisy told him to leave, or they threatened to call the police. There's none of that. It would have been on there, but they lost it. Nobody knows how. Everybody's saying, it wasn't me, I don't know, we did everything. It must have been the machine. It wasn't the machine. They gave the machine back to the owner, it worked fine. The only difference is a month's worth of footage is gone. I didn't delete it, the police did. The police lost it, the police destroyed it. What does that mean? They have it in their control and they lose it. That is incompetence of the highest order. This is a murder case. That is incompetence, ladies and gentlemen. You should consider that. We have a blood trail here, which begins in front of the house. The state will have you believe that at the time Pedro was shot, he was running away. He wasn't running away. He was running to the house. He was going to barricade himself inside that house where those kids were. He was going to keep her out, and he was going to do God knows what. I say God knows what because we already know what he did 5 days before. We already know that he snorted about a mountain of cocaine shortly before this happened. That was her home, which she has a right to defend. Pedro did not have an invitation or a right to be in that home. He made it clear that he was going to break into that home and lock her out and keep her away from her children, which he had no right to do. And importantly, she has every right to use deadly force to prevent him from doing that. And this is not just me talking, this is the law. This is the law, which I'm going to read to you in a moment. The law, I will remind you, that each and every one of you swore an oath to follow. Was Daisy honest with the police from the get-go? No, she wasn't. Okay? No, she wasn't. Should she have been? Probably. But can someone really understand what's going through somebody's mind when they're in that position? I think we can all agree that what happened to Daisy Link in the 5 days leading up to this incident was extraordinarily traumatic. Unless you've been through it, it's hard to imagine what that's like. I would say it's almost impossible to imagine what that's like unless you've actually experienced it. It's very easy to second guess and judge somebody for their actions when you don't know what was in their mind at the time they made it, ladies and gentlemen. As I told you before, relationships are complicated. How many times, how common is it to see a couple who clearly are wrong for each other, who clearly shouldn't be together, but for whatever reason they keep coming back to each other. They keep interacting. Maybe they separate, maybe they come back, maybe they go back. It happens. Well, that's because these things are complicated. There are children involved. There's a
complicated relationship. We want to hit the pause button because we want to let you know that in real time, the verdict clock is going. It is up there on your screen. The jury in real time has been added 4 minutes and a couple of seconds. Let's bring in trial attorney and family law attorney Michelle Tomas, who is with us. Let's talk about these closings. Yes, we're watching them because we don't want anyone to miss any moment of them. During the commercial breaks, we hit the pause button. So in real time, they are deliberating, but we're listening to the defense's closing, and there's this explanation for why the shooting victim here was shot in the back of the thigh, that he was running to the house to try and lock her out, and she was fearful. What do you think about that explanation when you have the prosecution saying, no, he was trying to get away from her because he saw she had a gun?
Yeah, well, good afternoon, Julian. Thanks so much for having me. I mean, I think the prosecution has a problem there because, again, the defense just has to raise reasonable doubt. And is it reasonable to believe that she could have shot him because of him threatening to keep her out or lock her out of the house and the children were inside? That is a plausible explanation. So it's going to come down to credibility. Now, of course, the defendant has a significant issue with credibility because she started out lying to the police during the investigation. But then on the witness stand, she was somewhat, I think, forthcoming and straightforward. So it's really going to be tough for this jury to really decipher between who was telling the truth. But I do think that it's a plausible explanation that the defense is putting forward.
Yeah, we know this jury is going to have three choices, essentially not guilty based on her self-defense argument. They could choose murder, second-degree murder, which is what she is charged with as a top count, but also manslaughter is a lesser one. I want to get your family law experience on this, Michelle. We've got this son who is there who had to testify in this really just unfortunate situation. His father is deceased, his mother is in jail, and he's living with his grandmother, and then he has to take the stand. When you see a child have to testify in a case like this one, what are your concerns?
I have seen this happen time and time again. And whenever you put a child in the middle, I mean, first of all, the child has so many.
All right, Michelle, we're going to work on your audio. We're going to hit a quick break and get back in for those closing arguments in the Daisy Link case. Thanks for being with us for your front row seat to justice.
Tonight on Closing Arguments, a parent's worst nightmare. A 5-year-old girl left unrecognizable after she was brutally beaten by other children. We'll dive deeper into this tragic case.
Closing Arguments, tonight at 8, 7 Central, only on Court TV.
Donna Edelson wasn't a regular mother.
She's the matriarch mastermind.
She's just being a parent, not a killer.
Victim to Verdict with Ted Rollins. Season finale, Saturday night at 8 Eastern and Pacific.
Only on Court TV.
A jury is deliberating the fate of Daisy Link right now, and we'll get back to watching those final closing arguments in Miami, Florida in just a moment. But first, let's get you an update out of Wisconsin. Closing arguments are about to get started there in the Caught in the Crossfire murder trial for Paris Larry Jr. Right now, the attorneys are working on final jury instructions. Larry was just 14 years old when this all happened. Prosecutors say he was involved with other people in the shooting that killed 20-year-old Tatiana Zek. She was shot in the head while she was taking out the trash after a cookout. 3 others were also injured as well. The defendant took the stand in his own defense at the last minute. The day before, he said he didn't want to testify, but he changed his mind, and he did say that he fired his gun, but said that he did it because he feared for his life.
So, why did you pull out that gun and fire it?
Keyshawn, I just saw Keyshawn and Johnston pulling out guns, and I was in fear for my life.
And you fired your gun before Keyshawn Johnson fired his gun, correct?
No.
And you fired almost simultaneous to Antonio Johnston, as you just said, correct?
Yes.
And one of your bullets could have been one of the bullets that killed Tatiana Zek, correct?
I object. Calls for speculation.
He has personal knowledge of being there, pointing the gun, identifying where his gun is at the time. He can answer the question.
Overruled.
What do that mean?
That means you can answer the question.
Yes.
And one of your bullets could have been the one that hit Javier when he was in his apartment.
Yes.
We'll continue to follow that trial and bring you updates throughout the day. But let's go back to Florida, where a jury is already deliberating the fate of Daisy Link. Her attorneys say that she shot her boyfriend, Pedro Jimenez, her husband rather, in self-defense, arguing that the two were in this tumultuous relationship marred by abuse and domestic violence. Prosecutors say she was the aggressor. Let's pick it up where we left off with the closing arguments from the defense attorney telling this jury she was the victim, not the villain.
This is a court order. This court order says Pedro gets to see those kids once in person, see them in person, once a month, with the supervision of his mother. Daisy had a fear, a reasonable fear, that if the court found out that she was allowing Pedro to see those kids in person, knowing that he's still being violent, knowing that he's still abusing drugs, a court could very easily and theoretically say, you know what, you're not supposed to have him around those kids, you know what he's doing, we're going to take those kids away from you. As a parent, is there anything scarier? Anything scarier than losing your kids? I don't think so. You can think something, I'd love to hear it. I can't think of anything. I'd rather be killed than lose my kids, personally. She feels the same way. That's why she did what she did. You can disagree with it. You can not like it. That's fine. That's your right. But that doesn't change the fact that at the time she pulled the trigger, she had every right to do so. This paper that you all have, jury instructions, this is the only law that applies in this case. There is no other law, no other instructions that apply to this case. You are to decide your verdict based on these instructions and these instructions alone. Okay? So let's go through the instructions. Page 3. This is a really loud one. I'm sorry, I can't have it. It's the best I can do, I'm sorry. Page 3. You all have it, so that helps. Justifiable homicide. Use of deadly force is justifiable if done while resisting an attempt to murder or commit a felony upon the defendant, in or upon any dwelling house which the defendant was at the time of the killing. Miss Link was at her home. She had every right to be there. Mr. Jimenez had no right to be there. I don't care if his kids were there. He had no right to be there. He had no right to see them. You saw the order. He did not live there. He did not have the keys. He was not on the lease. The address was not on his license. You've heard testimony from multiple people that he did not live there. You have not heard testimony from a single witness that said he lives there. They want you to believe he lives there because it's convenient for the case. They don't want you to believe that he didn't live there, which he didn't, because they know that if you know he didn't live there, they're done. Their case is over, and I'll explain that to you in a second. So the question is, has the state proven to you beyond a reasonable doubt that Pedro Jimenez lived in that house? No, they haven't. At best, maybe you can all say, yeah, I'm not sure. Maybe he did, maybe he didn't. What are they pointing to prove that he lived there? Because there are some shoes and some shirts that appear to be for males in the house? Does that prove he lived there? I'm sorry, it doesn't. And use your common sense, people, okay? I still have stuff at my old house, and I've been divorced for 10 years. It's still there. It's not my house. I don't live there. I don't have a key. I can't go there and come and go as I please. No, I have to knock on the door. I have to be allowed inside like everybody else. Was that my house before? Sure. It's not anymore. Do I still pay the mortgage? Yeah, I do, actually. But I still don't have a right to go in there because it's not my house anymore. That was not Pedro's house. And unless they prove that it was his house and that he lived there beyond a reasonable doubt, then no. And as far as you're concerned, that was not his house. He didn't live there. He did not have a right to be there. Same page, page 3. Excusable homicide. The killing of a human being is excusable and therefore lawful. The killing is lawful, which means it's not illegal. It is lawful, not a crime. Under any one of these following circumstances, when the killing is committed by accident or misfortune, and doing any lawful act by any lawful means in the ordinary caution, okay? Number 2, when the killing occurs by accident and misfortune in the heat of passion, upon sudden and specific provocation. Can you see how that scenario could apply to this case?
The defense, they're going through the elements of the law, walking the jury through self-defense, murder. We'll hear if they go through manslaughter and whether they tell them that would be a better choice than murder, but perhaps they will just stick to this is absolutely self-defense, nothing more. Let's bring in trial attorney and family law attorney Michelle Tomas. And I do want to let our viewers know, Michelle, in real time that the jury is getting a lot of information back into the deliberation room. We understand the court is getting together copies of transcripts and the complete autopsy photos and things of that nature. All the things that happen when a jury first starts deliberating. They make sure they have all of that information. The defense highlighted the cocaine in the shooting victim's system. How much does that impact things when we have a self-defense case?
Well, I think that it matters because in this case, she testified that when he was on drugs, that he became, quote unquote, a monster. And so would it be reasonable for her to believe that she was in danger and in imminent fear at the time of the altercation and that she pulled the trigger? So to the extent that he was on drugs in that moment, that makes her story and her narrative a bit more credible and plausible that she was justified in believing that she was in imminent fear and ultimately justified in killing.
And also this jury getting that police interview, that's going to give them a lot of that information that you're even talking about. What did she say initially to police? I also want to ask you about stand your ground, because the defense is getting really passionate in these moments that we were just hearing, and he's telling these jurors she had every right to be in her home. The judge denied a stand your ground claim initially, because that's a case that's almost separate from this case, a mini trial where the judge hears it and sees if it can even go to a jury. That was denied. So he can still talk about it, but it's not something that the jury's going to decide about. Stand your ground specifically, they're looking at was this self-defense. Tell me your thoughts on should this have been something that is a Florida stand your ground type case, because she was in her own home.
You know, I think that's a really interesting question. And I'm surprised at how much time actually that the defense counsel is spending on her ability to defend her own home and property. But he's really driving that point home. And so too, even though it wasn't initially ruled on as this being a stand your ground case and that she was justified, I do think that it puts into the jurors' minds that she may have been further justified in the killing because it was her home. She had every right to be there. And then critically, she had no a reason or requirement to retreat. So that she chose not to retreat, even though he was shot from the back, that would certainly bolster her claim as to why she should be acquitted on all counts.
Michelle Tomas, thanks for that analysis. Stand by. The jury continues to deliberate. They are 20 minutes in. We are continuing to watch the rest of the defense's closing argument in the toxic relationship murder trial in Miami, Florida for Daisy Link. Plus, we're also getting an update on another case that we're watching here on Court TV. Matt Johnson's going to join us for this one to get us up to speed to this one in Massachusetts for a firefighter from Ireland, Terrence Crosby, accused of rape. Welcome back to Court TV Live. I'm Julia Janae. Thank you for being with us. We've been watching the Daisy Link case out of Florida. Before we get you back inside of that courtroom, we do want to keep you updated on our newest live trial happening in Massachusetts. We're calling it the firefighter rape trial. The defendant there is Terrence Crosby, a 38-year-old man from Ireland. He's on trial for the second time on charges that he raped a woman in a Boston hotel. He was visiting Boston with fellow firefighters at the time, according to prosecutors. prosecutors. And while we have been in Daisy Link, this trial has been going on. So we have with us Court TV crime and justice correspondent Matt Johnson, who has been watching it for us, making sure we don't miss any major moments. Matt, thanks for being with us. Let's talk about the opening statements. They started today while we were in the middle of another trial. What stood out?
Much anticipated opening statements, and they didn't disappoint. Powerful from both sides in this retrial for Terrence Crosby. The Commonwealth of Massachusetts calling the Irish firefighter a visiting predator who thought that he could get away with rape, while his defense team questions the victim's memory, her changing story, according to them, and intoxication level.
Through her testimony and all of the evidence that corroborates it, we will prove to you that the defendant went into that room, raped as she slept, and continued to do so after she woke up and struggled to get him off of her. The defendant thought being far from home meant no one would ever know what he did. But by the end of this trial, you will.
This case is going to involve a lot of suspicion and maybes and what ifs. It's going to involve a lot of emotion. But we do not convict people on suspicion. We don't convict people on maybes. We don't convict people on what ifs. We don't convict people on emotion. Mr. Crosby should go home not guilty.
The defendant there that he was pointing at, his client, appears engaged at the defense table, was in a suit and tie. He testified during the first trial, which is also what we expect this time around, Julia.
Certainly, because we got a situation where this was the defendant's hotel room. He legally could go inside. He says he got in a bed and didn't know that she was not there for him. So I think a lot of people are wondering, what's the DNA? There's a rape kit that she got at the hospital. What does that say?
Well, that's going to be key to this case more than most cases. The DNA evidence, much talked about during opening statements. Both sides using it to their advantage. Take a listen.
DNA testing was later done on swabs from her genital area. 2 distinct male DNA profiles were found in one of those genital swabs. And while there was an insufficient amount of male DNA to compare it to a known person, there was enough to show that the DNA was left behind by 2 different males.
Not a single time did they find a trace of did they find a trace of Terrence Crosby's DNA? Not inside her, not outside her, not on her clothes, nowhere. The only identified male DNA found came from the other person in that room that night, Liam O'Brien.
We should also mention that when we drop the audio there, we are not identifying the victim in this case. That's per court order, so we're, of course, following that. Okay, so the attorneys also mentioned surveillance video from the bars, the hotel in question where this alleged event took place, and the flight that was booked by this defendant when he changed his flight to catch an earlier flight on a different airline after speaking with investigators. How much they get into with that during the trial will be very interesting.
Consciousness of guilt, perhaps. We know he was deemed a flight risk in terms of where he is able to move about if he gets out of jail. Let's talk about the jury makeup, because we got a situation where there was a mistrial the first time. Jury couldn't come to a decision. Who's on the jury this time?
Yeah, and during that first time, the jury deliberated for something like 22 hours before it was declared a mistrial. Here in the Boston area, it was 2 days of jury selection. The jury was asked their thoughts on immigration, people with Irish accents because he's expected to testify, and infidelity because he is married. Well, take a look. Here is the jury makeup. 8 men and 7 women. That includes the 3 alternates hearing the case. They're in the box right now. This defendant faces up to 20 years behind bars if convicted. As I already mentioned, he is married with children. His wife has been by his side during prior court proceedings, but she was not spotted in court today, according to our field producer.
A really interesting case, Matt. Thank you for watching it, monitoring it. We will get our viewers into it as soon as we wrap things up in Florida. Thanks so much. much. Still with us, speaking of that Florida case, the Daisy Link case, let's bring in trial and family law attorney Michelle Tomas, because Michelle, we've been watching the closing arguments in Daisy Link, and we understand that the jury, they in real time have been deliberating for 31 minutes, but they have a question, and they are about to go on the record inside of the courtroom to talk about their question. So we are going to take everyone in there as soon as we get audio inside of that courtroom. But while we wait for Daisy Link, do you have any comments you want to make on this rape trial that Matt Johnson just talked about?
Oh, that's a really fascinating one. I mean, and it really comes down to credibility. Here we have an alleged victim who went straight to the hospital. She obtained a rape kit. I mean, she took the steps necessary, but then you have the defendant who's denying it all. And so I'm really interested in how this one's going to unfold.
Oh, yeah. Okay, we're going to take a break. And when we come back, we should have live coverage inside of that courtroom in Miami, where the jury has a question in the case where they are deliberating over whether it was self-defense, murder, or manslaughter for Daisy Link.
I'm going to ask you a lot of intensely personal questions. How do you explain it? The worst crime anyone can imagine. Do you feel like you took the fall for this murder? Tell me in your own words, what happened? Let's get started.
Interview with a Killer. New season premieres Saturday, October 25th. Only on Court TV.
Welcome back to Court TV Live. We have breaking news out of California in the case of baby Emmanuel Haro. You'll remember that he went missing August 14th, and his parents initially said they didn't know anything about what happened to their child, that their child had been kidnapped by someone. Ultimately, on September 4th, they were arrested and charged with murder, and we're now getting multiple reports that confirm that the father of the missing 7-month-old has pleaded guilty to all charges, including second-degree murder. Jake Haro entered that guilty plea during what was scheduled as a felony settlement conference there inside the courtroom. That often happens in a case before it goes to trial. Reporters in the courtroom say Haro was visibly emotional, crying as he admitted to killing his infant son. Emmanuel's remains have not been located. Jake Haro's sentencing is scheduled for November 3rd. His wife, Rebecca Haro, who also faces murder charges in connection to the case, she continues to plead not guilty. According to what we know on the record, her felony settlement conference, similar to this one, has been scheduled for October 28th. Court TV will continue to follow this story and bring you all of the latest right here. Now let's turn our attention back to Florida for the toxic relationship murder trial for Daisy Link. The jury has been deliberating now in real time for 37 minutes. We got word earlier that they had a question, but they haven't gone on the record yet inside of the courtroom to talk about that question. Earlier this week, Link did take the stand in her own defense. She testified that Pedro Jimenez was an abusive and out-of-control partner. She said she shot him in self-defense, but the prosecution says she was the aggressor and that she lied about everything to police until she was confronted with those lies. So it is now in the hands of a jury. They've got to decide if this was self-defense, murder, or manslaughter. For now, we've been looking back at the defense team's closing arguments, playing it all out for you. So let's pick it up where we left off. This is the defense attorney for Daisy Link.
She grabbed the gun, she told him, leave. And you heard what he said. I'm not leaving, I want to die, I'm ready to die. And then he ran to go break into the house. Then she fired. And then, and only then, when she fired, that's when he started running away. It took the shot, it took her firing the gun for him to abandon his intention to break into her house. And if you are stopping somebody from breaking into your house, that is justifiable use of deadly force. And it was going to happen imminently. We know that. We saw the blood trail, we heard the testimony. He was going to break into her house. She did everything she could to stop him. He refused, so she fired the gun. And it worked, because when she fired the gun, he ran off to the alley. I want to talk about the instruction for second-degree murder. This is on page 4. You see it there. Three elements that the state has to prove beyond a reasonable doubt in order for you to be able to convict Daisy Lynn. And this is what your case is going to come down to. Number 2, the death was caused by the criminal act of the defendant. And number 3, there was an unlawful killing. So, I highlighted the relevant portions in 2 and 3, just to give you all a little guidance there. So, in order for you to convict her of anything, whether it's murder or manslaughter, of anything, you have to find that her firing that gun was a criminal act and that her killing Pedro was unlawful. So, in other words, what your deliberations are going to come down to is whether or not this killing was justified or not. Was Daisy justified in using deadly force or not? That's it. That's the decision you have to make, and that's going to be how you reach your verdict, okay? It says it right there. So, let's fast forward here. This is the key instruction in this case, ladies and gentlemen, page 8. It's the longest instruction out of all of them. It's, oh boy, look at that, it's 3 pages. It's 3 pages long. So, sorry, but we need to go through it. Justifiable use of deadly force. 3rd paragraph, okay? Defendant does not have the burden of proving that she was justified in using deadly force. Instead, for you to find her guilty, the state must prove beyond a reasonable doubt that she was not justified. This is what I said earlier. I don't have to prove that she was justified. It's the other way around. They have to prove she was not justified. So have they proven that she's not justified? Have they proven it beyond all reasonable doubt? Well, let's see. Let's have a look. Keep reading. The law on justifiable use of deadly force is as follows. Defendant is justified in using deadly force if she reasonably believed that such force was necessary to prevent the following: imminent death of great bodily harm to herself or another. So if she believes that imminently means it's about to happen, it's going to happen any moment now, that she's going to get hurt or another person's going to get hurt, you have the right to use deadly force in that instance. Okay? And then there's another option. Or B, the imminent commission of burglary or false imprisonment against herself or another. At the time that she shot, Pedro Jimenez was running to break into her house, to barricade her out of her house. Okay? He had no right to be there. When you enter somebody's house without permission, that's burglary. I'm going to read you the definition of burglary in a moment. So that's number 1. That's one felony that he was about to commit, which, according to this instruction, if she knows that he's about to commit a burglary upon her house, she has the right to shoot him, to stop him. This is the law that you are required to follow. In addition to burglary, false imprisonment. There are 2 kids in that house. Those kids are in her custody, not in Pedro's custody, her custody. By barricading himself inside the house, Pedro would be illegally separating those kids by force from their mother, without permission, without authority, without any right to do so. She has a right to use deadly force if she has reason to believe that that's about to happen. And we all know that that was about to happen. He was about to burglarize her home. He was about to lock her out of her home and commit false imprisonment upon her kids. So, moving on to the next part. This long paragraph here, right here on page 4, on page 8, this paragraph has to do with whether or not Daisy Link had a duty to retreat or not a duty to retreat. You can go through that and read it to yourself, but ladies and gentlemen, as you will see in a moment, she had no duty to retreat because she had every right to be there because that was her home. On the other hand, Pedro Jimenez had no right to be there because that was not his home. He had been told repeatedly to leave. He had been threatened that they would call the police. And he did leave, but he kept coming back. Multiple times, he kept coming back, kept terrorizing this woman. She did it while her mother was there, and then he did it again after his mother left. His mother left at 1:32 in the morning, and he still came back after that. He's terrorizing her at 3 o'clock, 3-something in the morning. I'm going to refer you to page 8 at the bottom right here. If the defendant was in a dwelling or residence in which she had a right to be, which she did, she had no duty to retreat and had the right to stand her ground and use or threaten to use force, including deadly force, if she reasonably believed that such conduct was necessary to prevent death or great bodily harm to herself or another, or the imminent commission of a burglary or a false imprisonment against herself or another. So again, this says, again, if she has reason to believe, well, first of all, it says if she's in a place where she has a right to be, there's no question she had every right to be there. That was her home. If she's in a place where she has a right to be, she can use deadly force to stop somebody from burglarizing her home and to stop somebody from keeping her outside of the home and keeping her away from her kids who are inside the home. She had a right to use deadly force in each of those and in both of those. This is the law that you are required to follow. After this defines the crimes of burglary and false imprisonment. These are the two crimes that I would submit to you. The evidence has clearly demonstrated Pedro Jimenez was intent on doing and was in the process of doing, and the only reason he stopped from doing it is because she fired that shot. That was...
Hitting the pause button on this, we can bring back in trial and family law attorney Michelle Tomas. We're about to get to our break, Michelle, but what do you think about how the defense is laying this out? He's even laying out the crimes that the alleged victim in this case would have done. What's the jury going to come back with here, in your opinion? Self-defense, not guilty, manslaughter, or murder?
You know, I mean, I think that the defense is doing a compelling job. I mean, he's like, even though stand your ground wasn't formally granted as a defense, he's laying out the basis, the foundation for why she was legally in the right to shoot him. It's really was like a preemptive act that she made. So I think that the jury's going to be really difficult here because she was in her own home. There were threatening acts made. She represented that she believed he was going to run into the home and barricade, the children and possibly do harm to her or the kids. And so she then, under those circumstances, had a right to kill him. So I think it's going to be really difficult for this jury to parse through whether that defense is essentially enough to acquit her, or they're going to say that find her not credible and it's going to be murder.
48 minutes they've been at it. Michelle Tomas, thanks so much. We're still getting word about that jury question. They haven't gone on the record. More of the closing arguments and monitoring this case after this.
Welcome back to Court TV Live. I'm Judge Ashley Wilcott, of course, honored to be with you. And we have breaking news. Court TV can now confirm that the father of missing 7-year-old Emmanuel Haro has admitted to killing his son. Just moments ago, we got the court documents that say Jake Haro, there he is, has pleaded guilty to all charges, including second-degree murder. Reporters in the courtroom say that at today's hearing, Haro was visibly emotional, crying as he admitted to killing his own infant son. Jake Haro will return to court on November 3rd, next month, for sentencing. Now, his wife, Rebecca, she also faces murder charges in connection with the case. So far, no details yet as to whether or not she will change her plea. Her next court date is this month. That is set for October 28th. Baby Emmanuel was reported missing back in May. His remains have not been located. Hopefully that will be coming. Let's bring in now criminal defense attorney Laura Yaretzian. Laura, good. I'm glad that he has entered a plea if he did this, which he says he did, murdered his own infant son, but still the missing piece of where the body is. What are your thoughts?
There's always a possibility that he may cooperate with the prosecution and law enforcement to get some leniency as far as sentencing is concerned. And as part of that, he may tell them where the remains are, or give them specifics as far as what happened.
That's right. That's what we're hoping for in the name of justice for this little beautiful baby boy. And the reality of, what do you think about, because we've seen cases in which a defendant is either convicted of murder of a child or in the alternative pleads guilty to murder of a child, but they don't show emotion. The reporter inside the courtroom has said he was very emotional as he entered this plea. Does that say anything to you?
I mean, it shows you that that's a father who's lost a child, but it may mean that maybe there was some negligence or accidental killing, or maybe he wasn't in the right state of mind, or he was under the influence of drugs. This is somebody who basically cares or cared about the child and is showing emotions, and maybe he's basically feeling sorry for what he did. And that could go a long way. Remorse is in cases like this.
Yes, and we'll see whether or not there's more remorse shown by the father. Again, he has pled guilty to the murdering his own son, Emmanuel. All right, now we want to turn back to Florida, where a jury has begun deliberating the fate of Daisy Link. We hear the jury has a question. Of course, we will take you there live once the court resumes and goes back on the record. Attorneys for Daisy Link says that she shot her boyfriend, Pedro Jimenez, in self-defense, arguing that the two were in a tumultuous relationship marred by abuse and domestic violence, including pistol whipping. But prosecutors believe that Link was the aggressor. While we wait for that verdict to come down or the question the jury may have, we are watching the defense team's closing argument. We want to bring all of that to you in its entirety. Let's go back in for more.
That was the only way that she was going to stop him from doing that. And we know that from Pedro Jimenez himself. I'm ready to die. What does that mean? I'm going to do what I want. You want to stop me? You're going to have to kill me. You're going to have to kill me. Burglary. Entering a dwelling owned by or in the possession of another, and at the time of entering the dwelling, the unauthorized person had the intent to commit the crime of false imprisonment. Please tell me, how has the state disproven that this was about to happen? Can you honestly say to me that the state has convinced you beyond all reasonable doubt that Pedro Jimenez was not in the process of rushing in to barricade himself inside that house and lock Daisy Link out? Have they disproven that beyond a reasonable doubt? If the answer is no, then your verdict is not guilty. If the answer is yes, then okay, then I would ask you to ask yourself, how have they proven it? What have they shown? What have they introduced to prove that? I would submit to you they've introduced nothing. Nothing. to disprove that that man was going to do that. Certainly not beyond a reasonable doubt. That's burglary. False imprisonment. That's the next one. We're still on page 9. It's right here. False imprisonment is defined as follows: to forcibly or secretly confine or abduct another person without lawful authority to do so. Forcibly would apply here. He was attempting to forcibly confine those kids within that house and keep the mother out of the house. The next paragraph defines secretly. You're free to read that as much as you want, but secretly doesn't apply here, so I'm not concerned with that. The next paragraph is very important. Very important. Confinement of a child under the age of 13 is against the child's will if such confinement is without the consent of the child's parent or legal guardian. In other words, if you're locking 2 kids inside a house against the will of those kids' legal guardian, and those kids are under the age of 13, which, as you already know, those kids were ages 7 and 5 at the time, then that's false imprisonment. We know that Pedro was not their legal guardian because that's what this order says. So unless the state is going to come up here and find a way to invalidate this court order, which if they have a way to do that, I'd love to hear it. They're not going to. This is a court order, this is a valid court order, and this court order was in place, in full force, on that night. Daisy Lake asked him to leave. He did not respect her request to leave. He was going to commit false imprisonment. And that is what this instruction tells you. I'm going to keep reading. Please bear with me, but again, this is a long instruction, but it is the most important instruction in this case, because this is what your deliberations are going to come down to. In deciding whether the defendant was justified in the use of deadly force, you must consider the circumstances at the time the force was used. The danger need not have been actual. I'll say that again. The danger need not have been actual. So it's actually legal to use deadly force against somebody, even if there's no real danger. The key is whether the person using the force reasonably believed that the danger was there. Now, I would submit to you, there's no question that the danger was real. There's no question that the danger was imminent. But this instruction shows you that even in cases where there's no real danger, if you find that the person who used deadly force had reason to believe that there was a danger, that's enough. That's enough to say that the use of deadly force was justified and lawful. I'll keep reading. To justify the use of deadly force, the appearance of imminent danger must have been so real that the defendant actually believed the use of deadly force was necessary. Pedro told her, "You're going to have to kill me, I'm ready to die." What else was she supposed to believe? What else was she supposed to believe? She didn't put herself in that situation. He put her in that situation. The state will tell you, oh no, she brought him to the house, so it's her fault. No, she brought him to the house. She knew she was going to leave. First of all, she was supposed to pick him up and take him to his mother's house, but she explained to you she came back because he still had his keys. She wanted him to see the kids. She wanted to make it work so that she could get away from this man finally, move away from him, not have to deal with him beating her up. And she was implementing her plan. Whether it was a good plan or not, that's up to you to decide. But that was her plan, that's what you heard. It has not been refuted by the state in any way, shape, or form. She went to pick him up. She came over. She came over while her mother was there, and you heard from her mother and you heard from her. He was obviously high on cocaine because he used a bunch of cocaine at his friend's house. He bought a bunch of cocaine from his friend. He was drinking. You heard what was in his system when he died. He was extremely under the influence of a ridiculous amount of cocaine. He was drunk. He was out of control. She brought him back, and as soon as he started becoming violent, which he did on multiple occasions, as you heard from her mother and from her, as soon as that happened, he was told to leave. He was told, 5 different times to leave? And 5 different times he left. 5 different times he came back. You saw video of him running around. There's a video of him being told to leave a few hours before he was shot. How many times does this woman have to tell him to leave? Once is enough. Once is all it takes. It's my house. You need to leave.
The defense arguing to the jury some of the jury instructions, including, listen, you have to ask yourself, was the defendant justified in using deadly force, and that danger does not need to be actual. Tell us what you think. Go into social media, weigh in. The jury currently is deciding the fate of Daisy Link. We're just bringing the closing arguments to you in their entirety. We'll have more of the defense's closing argument right after this short break.
Tonight on Closing Arguments, a parent's worst nightmare, a 5-year-old girl left unrecognizable after she was brutally beaten by other children. We'll dive deeper into this tragic case.
Closing Arguments, tonight at 8, 7 Central, only on Court TV.
Donna Edelson wasn't a regular mother.
She's the matriarch mastermind.
She's just being a parent, not a killer.
Victim to Verdict with Ted Rollins. Season finale, Saturday night at 8 Eastern and Pacific.
Only on Court TV.
On June 25th, 2022, Pedro Jimenez was murdered. He was murdered by his 9-year relationship, his spouse, his wife, his defendant, Daisy Link. This is a toxic relationship. 2 people that should have never been together. Ms. Link said Pedro Jimenez was a good guy. I disagree. I don't think he was a good guy. But he didn't deserve to be murdered that day.
Back now to Florida, where deliberations remain underway for defendant Daisy Link as she stands trial in the shooting death of her boyfriend. We have the clock up. It's been about an hour and 10 minutes. Link did take the stand yesterday where she testified that she shot at Pedro in an effort to scare him off, not realizing that she would actually hit him. Pedro was shot in the foot, which then traveled through his leg, hitting an artery and causing him to die. Now, while we are waiting for the jury to return after they told the judge that they have a question while they're deliberating, the court is now back on the record without the jury present. Let's go in and listen together.
We're back on the record. Mr. Tomas, do me a favor. Take those photographs and show them to your client. So Ms. Link's back on record. Ms. Link is here, Mr. Tomas, Mr. Brigida, Mr. Octala. Jury's still deliberating. We dealt with one question regarding, the full question escapes me now. They're referencing evidence of a back door. The lawyers and I reasonably believe that it's probably a photograph that Mr. Brigida, you referenced in your closing as a demonstrative aid. You've printed out those photographs. Mr. Tomas has them now.
And Judge,
Hold on. And then Mayor Elise, I'm gonna have those 5 as a composite for now. Mr. Tomas, I'm gonna give them back to you. Let the clerk mark them as a composite.
before we do that, I need to swap out a photograph.
So there's 5 right now, but one of them's a duplicate?
Correct.
You only want me to mark it, right?
Just mark it for now.
2G.
So the substance of the photographs that the state referenced in their closing are the outside of Miss Daisy's home, which encompasses a duplex. There is a fifth one that, Mr. Tomas, you found in your discovery.
Yes, ma'am.
And what does that one show?
So that one shows inside, shows the home, shows the door, I believe it's the back door, and very close to the back door there's a window that you can tell it's in place of glass, there are other things there.
Cardboard.
And this would, I think this would go towards the specific question that the jury asked about, I think they were alluding to the testimony that Pedro stuck his hand through the window to unlock the door.
Because at one point during the state's closing, some reference was made about how tall he was, and Mr. Brigida is not as tall as him. Something along those lines. If you remember it better than me, let me know. But something along the lines of reaching in and how nothing of the outside. The inference was nothing on the outside was damaged. From where I was sitting, that was the gist of the state's closing argument on that point.
Yeah, I recall, I guess the impression that I got was that this that I'm showing you shows that he couldn't have reached in and opened the door.
I got the same impression. But those photographs that were used as a demonstrative aid are not in evidence?
Well, so yes and no. When I was creating this presentation yesterday, I have a good faith basis to believe that at least some, if not all, of these photos are in evidence. I obviously do not have access to evidence once we are done for the day. I have reason to believe, based off of the testimony, as well as the introduction, as well as conversations I've had with co-counsels, that those photographs were introduced. The other photograph, and it's 100% my fault. I missed it. Mr. Tomas brought it to my attention when we were outside of the hall, I believe. I would not have made the argument that I had made. I would have changed it a little bit. It would have been something similar, but I still would have made the same argument. But I still have reason to believe those four should be.
So just print out the duplicate one. Are you going to go get it for us, Mr. Aftala?
Yes, Your Honor. I'll go to the back. Or no, actually, I have to go across the street to go and grab it.
Can you make your way over there now?
Yes, Your Honor.
Thank you. So, how else do I fix this?
I don't believe it's fundamental error, Your Honor. I understand your concerns. I genuinely do, and I lean conservative when it comes to. No, I'm sorry. I lean very conservative when it comes to those kinds of things. It wasn't a predominant feature of my closing.
It was the first question that the jury. They're in there for maybe 10 or 15 minutes, and that was the first question that they had for us.
I understand. If the court wants to send an instruction back.
Do you have any other suggestions?
I think by agreement we can send in those photos. I don't know what else the court had in mind.
By agreement, you referenced the tattoo of Daisy on his arm. That was part of the autopsy. That photo may not have been part of the evidence. By agreement of the parties, we agreed because it was referenced in the autopsy. It went back as stipulation. That was number 30 what? 31. This is a little different. It's one thing for them to be in a 9-year relationship. They've got 2 kids. They love each other. There's ups and downs. Him having Daisy on his arm, that corroborates parts of the state's case, doesn't go to the core of either the elements of the crime or the defense to the crime. This does, because it goes to credibility of witnesses. Why shouldn't I bring this jury out and allow Mr. Tomas a minute to explain to them his version of that photograph?
That's fine.
So the only issue is with that, and genuinely, I understand the court's concerns. I have the same concerns. Had I known that this photograph with the back door existed, and it's 100% my screw up. I am completely at fault.
Listen, I take you at your word.
I missed this. I would have still used this photograph, and I would have explained the same exact thing. I don't have an issue with Mr. Tomas being able to explain his version of events.
What would you have explained?
I would have said the window is still far from the door, and that this window appears like it was fixed. And if all of this was going on in the middle of the night, do we really think that this got fixed between the time and the shooting? That's what the argument I would have made.
But your argument is premised upon what you remember of these witnesses saying he stuck his hand through the door that day. I don't remember that specifically.
No, I believe the defendant's mother said that happened that night in between her being choked, or not the defendant's mother being choked, but the defendant being choked.
I don't remember. What do you remember? Why don't you confer with your client also?
The jury's asking for a lot after an hour. Let's bring in criminal defense attorney Laura Yaretsian just to recap what the jury's looking for. And the judge said, first of all, getting 6 copies and copies of the transcripts, as well as composite autopsy photos. The jury asked about a picture showing the back door. So there's debate between the attorneys and the court about that. Also, a demonstrative aid. It was an autopsy poster that was used as a demonstrative aid, and the judge said, send it all back to the jury. Laura, to me, this means they're digging deep into the self-defense claim to really figure out if they believe that was the case.
And that's exactly what I see here too. This isn't just one item, a discovery item that they're asking for, or evidence that they're asking for. They're asking for a number of things. And one of these items, there seems to be an issue, and the judge is very concerned about because she, and the jury is clearly focused on it, because she believes that there may have been a misrepresentation, and it may not have been an intentional misrepresentation or version by the prosecution. And now she's considering giving the defense an opportunity to maybe even have a 1-minute closing argument to address that. This is a jury that's taken its job very seriously. These jurors, if this was a slam dunk, we wouldn't have so many questions, right? We wouldn't have the jury asking for a demonstrative aid. They wouldn't be asking for transcripts. We're talking about several transcripts, photos, you name it. This is a good sign for the defense.
And I would agree that the evidence presented warrants a deep dive, because certainly I think both sides have very legitimate arguments based on the evidence presented. So I agree with you. The jury is doing their job. Let me ask you this, because I really appreciate that the prosecutor said, I had a good faith basis to believe photos were in evidence when I was creating our demonstrative aid. She said, but the problem is I didn't actually have access to the photos when I did it. And here's what she says to the judge, and I want to use her words because I'm impressed. This is how it should work in a court of law. She said, and I apologize, I can't find here it is. I screwed up. I made a mistake. I'll do whatever the jury wants and take it on the chin. The reality is we're people, and when we're in there, it is so much work to prepare for a trial, to try a case. It's exhausting, no matter how prepared you are. So I appreciate she was just honest with the court. What do you think?
And yes, and like you said, we're all human, but then you have to remember, if there's a mistake that could influence or impact the jury decision one way or the other, that could be problematic later on. So if it's an error of some sort that can be corrected, now this is the time to do it. Otherwise, it may be too late. And if there's a conviction, depending on how material and how exonerating that evidence is, or if it's very incriminating and the jury's considering it and it shouldn't have been presented, then that could be a reason for overturning a conviction. So the judge has to, I understand she's taking the human side of it and a mistake and admitting to all of that, but it is important to also address the issue now.
I agree with you, and I think any judge knows they need to address it now. They need to make a record of the decision they make for the reason they make it, and if it's correctable now, much, much better than leaving it open as an appellate issue. All right, Laura, stand by, please. Up next, we're going to take a quick break, but we are bringing you the defense closing arguments in their entirety. We'll be right back. Welcome back to Court TV Live. I'm Ashley Wilcott. Thank you so much for being with us. We are covering a lot for you right now. We want to return to Miami, Florida for more closing arguments in the toxic relationship murder trial for the defendant Daisy Link. The jury has now been deliberating for 1 hour and 25 minutes. Now, they had a question. They asked for some photos presented during closing arguments that had not been presented as evidence in the trial. Now, both sides and the judge discussed it outside the jury's presence, and the judge ruled that the photos will be admitted so the jury will get to see those. In this case, Daisy Link is a 30-year-old accused of shooting and killing her on-again, off-again partner, Pedro Jimenez, in June of 2022. As we mentioned, the jury now has the case, but right now we want to bring you more of the defense's closing argument.
It's my house. You need to leave. You need to leave. If you don't leave, you're committing a crime by not leaving, okay? You're committing a crime. But he knew that she didn't want to call the police on him. He knew that for whatever reason, and she shouldn't have, but for whatever reason, unfortunately, she had a soft spot for this man, and she kept giving him opportunity after opportunity, even though, as we all know, she probably shouldn't have. But again, relationships are complicated, and you can judge her all you want, you can disagree with her all you want, but you don't know what it was like for her. And that's the decision she made. And it's understandable because, again, relationships are complicated, and that's the position that she was in. But she didn't create this position. She asked him to leave. He put her in that position by coming back repeatedly. I'm at the bottom of page 9. The defendant is presumed to have held a reasonable fear of imminent peril of death or great bodily harm to herself or another when using defensive force that was intended or likely to cause death or great bodily harm to another if, this is important, A, the person against whom the defensive force was used was in the process of unlawfully and forcefully entering or had unlawfully and forcefully entered a dwelling, residence, or occupied vehicle. This is black and white. There's no room for interpretation here. You are presumed to be in reasonable fear and justified to use deadly force if somebody is in the process of unlawfully and forcefully entering your home. That is exactly what he was doing. And unless they can prove to you beyond all reasonable doubt that that's not what he was doing, then your verdict is not guilty. Anything other than that would be a disgrace. And I know you all don't want to make a disgrace here. I think you all want to get it right. There's only one right answer here, okay? I'm confident that you're going to get the right answer. I want to go to the next page. The next paragraph B. Defendant knew or had reason to believe that an unlawful and forcible entry or unlawful and forcible act was occurring. This goes hand in hand with the previous one. Reason to believe it was occurring. He told her he was going to do it. He told her, you're going to have to kill me. And she saw him doing it. And the blood trail which begins in front of that front door corroborates what she told you. The state has given you nothing to dispute or disprove that. The next paragraph, this is page 10, right over here. The very next paragraph talks about situations where the presumption of reasonable fear does not apply. Okay? So if any of these examples, there's 4 examples, if any of them were to apply, then you could come to the conclusion that, okay, well then this person didn't have a reason to believe that she was in danger of something bad happening to her. I'm going to start with the last one, with D, because this one's easy. The person against whom the defensive force is used is law enforcement. Look, Pedro Jimenez is not a law enforcement official, so we know D doesn't apply. So you can scratch out D. D is useless to you, okay? C, the person who uses defensive force is engaged in a criminal activity or is using the residence to further a criminal activity. This doesn't apply either. Daisy was not using her home to conduct a criminal activity, and she was not committing a crime when she was just at home in her front yard, minding her own business. So C does not apply. You can disregard C. B, the person or persons sought to be removed is a child or grandchild. Pedro Jimenez is a grown man. He's a grown man who's 6'4" and weighs 250 or 60 pounds, and he could easily beat the crap out of Daisy whenever he wants, and he has on multiple occasions. So B doesn't apply. So all that's left is A. So let's read A. The person against whom the defensive force is used has the right to be or is a lawful resident of the residence, such as an owner, lessee, or title holder. Has the state proven to you, beyond a reasonable doubt, that Pedro is a lawful resident, owner, lessee, or title holder? No. They got up here and they told you over and over it was his home, he lived there, they were family. They can say it till they're blue in the face. They have to prove it. Have they proven it? No. The only proof you've received on that topic is that it wasn't his home. You have lease agreements that he's not on. You have his license that he's not on. You have testimony showing that the locks were changed. You have testimony that he lived at his mother's house. Would he go over there to see the kids? Yes, but that doesn't mean that he lived there. All the evidence that you've heard proves that he did not live there. At best, you can say, well, maybe he did, maybe he didn't. But if that's your conclusion, then it has not been proven beyond a reasonable doubt. And again, the state has to prove their case beyond a reasonable doubt. They have not done so. I want to focus on this paragraph, which is right after A, B, C, and D. A person who unlawfully and by force enters or attempts to enter another's residence is presumed to be doing so with the intent to commit an unlawful act involving force or violence.